Ethical decisions are enforced by the Commissioner through regulations. However, not every ethical situation is addressed by law. We've discussed how producers and agencies have ethical concerns on a daily basis. The discussion on advertising may have brought back some memories of your pre-licensing days, and we introduce you to the ethical principles that guide advertising. States have an interest in how you and your insurance companies market and advertise the products they offer, and have implemented a host of regulations that must be adhered to. Unfair trade practices were discussed, and we included information regarding not only what is allowed, but also what is prohibited. Don't exaggerate, don't lie, be honest, and disclose the good and the bad of the product. We define prohibited sales practices for you, and these prohibitions will be enforced by the states and the federal government depending on the violation. The next section encompasses the Unfair Trade Practices Act. The Act was originally legislated in 1990 and has been amended several times since. You'll learn what are considered unfair practices from both the producer and the carrier. We'll specifically define unfair trade practices and show you how to avoid them. A carrier found responsible for violations of this nature could lose their certificate of authority and the ability to operate in a state. In the insurance business, if a carrier is sanctioned in one state, it's usually only a matter of time before they'll be sanctioned in all the states they operate in. This can also be true for producers. If you're penalized in your resident license state for a violation, and you hold non-resident licenses in other states, the non-resident states will be informed of your problems in your home state. The other states can then follow suit and discipline you as well. We're also going to explore the concept of rebating a client, which is illegal in all states. Remember, a rebate is a kickback of either premium or commission used as an illegal inducement to have a person buy or renew a policy. There are allowances for things like promotional materials, calendars, keychains, and things of that nature, but these are not considered illegal inducements. As long as they're not conditioned on a person actually buying or renewing a contract, they're perfectly legal. Most states do have limits on the value of consideration given to the applicant or policyholder, but other than that, promotional items cause no legal issues. We'll learn that the only way a producer can legally use the title of financial planner is if they actually are a financial planner with proper credentials. Unfair discrimination is looked at again, but this time we consider different aspects, such as complaint procedures, the ethics concern with the failure to address certain legal requirements, and failures regarding record keeping. If a producer doesn't maintain proper accounting procedures and cannot account for certain funds, it's both a legal and ethical violation. Inaccurate accounting points to a lack of both professionalism and the mandate to keep records to make sure client funds are properly accounted for. You'll learn the definition of favored agent or insurer and the prohibitions against them. Finally, we'll examine what happens when you're subpoenaed by the state and are required to testify in a disciplinary action against another producer or against an insurer. You'll learn that you do have certain rights and constitutional protections in place.